Welcome to the next episode of Called to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing we say should be thoroughly taken to have been thoroughly peer-reviewed. I'm Dr. Tamsin Philippa Paige, Senior Lecturer at Deakin Law School, and I'm joined today by Dr. Emily Jones, a New Act Fellow at Newcastle Law School in the UK. Today we are discussing Emily's work on posthuman feminism, what it is and what it means for international law. Emily, before we get down to these important questions, first, the most important question for Call to the Bar, what's your drink?
Well, first of all, it's an absolute pleasure to be here. So thank you so much for inviting me. I'm a big fan of the podcast. So, but yeah, of course, what is my drink being the important question? Well, it's 9 a.m. in the morning here. So very boringly, I have coffee, which I made on my stovetop, and being, exceedingly millennial, it is with oat milk, which I know is not very cool anymore, apparently, according to my social media, but whatever. But I am sure you have a much more exciting answer to give us. So Tamsin, what is your drink today?
So it's evening here because time zones are a thing. So greetings from the future. And as a result, I am having a low caffeine raspberry and hibiscus green tea that's from my favorite tea merchants who are tea runners. I don't know where they've sourced it from, but it's a really light green tea. It's absolutely just kind of raspberry pink in color, which is phenomenal. I love it. And it's got this beautiful kind of that tart raspberry kind of punch behind the green tea, and I'm really enjoying it.
Wow, sounds amazing. Very, very fancy.
So now, fine tradition for when people first appear here on the podcast is we discuss how we got to know each other. So from my memory, we met digitally when you accidentally misspelt my name in a book review you wrote on Diotto's Queering International Law. But we met properly in 2019 when you came over to Australia for ANZL and you presented a paper on posthuman feminism and military technologies and had a visiting position at Melbourne Law School. From there, we had some dinners out. We went to the NGV to see the Terracotta Army exhibit, and friendship ensued. How did this story look from your telling?
Well, first of all, I think we should also not forget drinks at the Sydney Opera House recently, which was really good fun. But yes, the misspelling of your name was such a terrible first way to have met you. And yeah, that obviously wasn't the first time. I am dyslexic, so it kind of brought back memories of when I was 5 and I misspelled daddy on my dad's Christmas stocking and I wrote baddie. And then I thought he wasn't going to get any presents from Santa because of that and felt guilty forever. So, yeah, I have to kind of find ways to manage that over the years. And mostly I'm okay, but sometimes I clearly fail at managing it. So, yeah, apologies again for misspelling your name.
Oh, there's no need to apologize. I'm dyslexic as well. It happens. I wasn't worried. And for context for our listeners, I just emailed the editors to get them to correct it on the digital thing and the print copy, and didn't involve you at all because I didn't want to cause you any grief. So, it wasn't an issue.
It was good because then it meant it was definitely going to be spelled correctly as well without me messing up at the edits. Yes, but yeah, I think the better version of the story is probably us meeting at ANZL, which is the first time we met in person. And I remember that really clearly because I just remember seeing you and being like, oh my God, she's so cool. She has like really great style. She's got all these tattoos. And like, I just felt instantly really comfortable with you. And I remember sort of speaking to Di afterwards, to Diane Otto, of course, who's a wonderful mentor to both of us. And she said to me, oh, it's like you and Tamsin just like instantly had this queer connection. And it was so nice to see. And I was like, yeah, I think we do. So that was really, really lovely.
Yeah, it was lovely, and we definitely had an instant queer kinship connection, and it was delightful, and I think it's enduring well beyond that point. So yeah. All right, so continuing on from that, For our early career listeners, perhaps you could say something about how you got into international law and the career path that's brought you to your current job.
Yeah, so I was kind of wondering where to start with this question. I think it probably all started when I was 16 and I was in Essex, which is where I grew up, which has a very bad reputation in the UK, but there's lots of good things about Essex too. And I had gotten kind of okay GCSEs, which is like the exam you do at the age of 16 here. But the school I went to wasn't very good, and I hadn't really gone to school that often. So yeah, I could have kind of done better. So then I did my A levels, which you do age 16 to 18 typically here. And the very last minute, I switched from double maths to doing law, just because I decided I don't know if I even want to do maths. Why am I even doing this? And I'm really, really glad I did, because I would never have thought of studying law otherwise. And I had this really amazing teacher called Dave, who just like, I was like a bit of a cheeky teenager and a bit of trouble. And he just really saw that I was quite smart and really, really pushed me to do well. So I think that that was the start of it, really. And yeah, from there, I kind of followed Dave's advice, and I ended up writing to a load of law firms at the age of 16 and being like, hey, can I do work experience with you? And nobody really replied apart from one, which was Matrix Chambers, who are actually, of course, really amazing barristers' chambers in London, which I didn't really know that they were that amazing. And I kind of went along. And I think, to be honest, that was really important for me, because I then wanted to apply to the LSE. That was my dream, to study law at the LSE. And of course, to get into the LSE, you not only need straight A's, but it's just like nearly impossible. Even all the people with straight A's don't get in. I'm pretty sure that I did get in because of that work experience at Matrix Chambers. I got accepted on the last day of offers. So yeah, so that's kind of how it all started. I studied law there, and that's when I started working for lots of feminist organizations and NGOs as well, which I really enjoyed. I then did my master's, which was actually in gender and the law, but it was an MA, which I did at UCL. So I know you've talked in the past about how in Australia, everybody has quite an interdisciplinary background. I guess I'm a bit unusual in that I do for a British person. Yeah, and then I did my PhD at SOAS in feminist approaches to international law. But I guess in terms of then how I got a job, I know, Tamsin, you've spoken about how you really chose to focus on like security debates in international law, and that was like your way of being taken seriously and getting a job. But for me, I've always done weird research. Basically, the reason I got my first job at the University of Essex is because I could teach tort law. I taught tort and property at SOAS. I was hired for tort law at Essex, and I would totally never have gotten that job based purely on my international law skills. And now I have this amazing job that's research only, that they actually hired me for my research for and my international law skills. But if it weren't for tort, I would never have gotten a job. So I guess in terms of tips for people in the future and people that are looking to get a job, teach a core law subject, and tort's a good one because it's quite fun.
I can say that from my experience in the school exec at Deakin, if people can teach trusts or property, that's a shoo-in for at least an interview. If everything else on your CV is good, if you can teach trusts or property, at least at Deakin, I'm pretty certain there'll be subjects like that at other institutions, but yeah, they're the area that we are most or often most needing people to come in. So I agree with that sentiment entirely.
Yeah, so two strategies there. One, you could follow the Tamsin path of doing something sort of recognizable international law. The other one, just teach tort law or trusts or property.
Fantastic. Well, so let's get to the main event. So our listeners have already heard me talk about queer theory and why it's important to international law a little bit when we had Holly come on in the episode about the Julian Assange saga. You've recently written a book and edited another one on posthuman feminism and international law. You've also contributed a chapter to the forthcoming book, Queer Engagements with International Law, that uses posthuman feminism and queer theories and looks at the environment. So can you tell us, well, what is posthuman feminism? For our listeners, what do we mean by posthuman feminism? How is that different from other forms of feminism and queer theory? And what does all of this mean for international law?
Great, a series of big questions. So I'll do my best, and if I don't make sense, then do just tell me to rephrase. But yeah, starting off with what is post-human feminism. So this is really a theory that's come from the humanities, but it's increasingly being used in other disciplines. And it seeks to dismantle hierarchies between the human and the non-human. So thinking, for example, about the environment and the non-human animal and challenging anthropocentric thought. But what post-human feminism does that also separates it from other forms of post-humanism, or I would also say new materialism, which is another kind of body of work that you might hear that label being thrown around, is that it also focuses on dismantling the hierarchies between humans. So really gender, race, class, ableism, etc. So yeah, it's kind of focusing on multiple inequalities at the same time, which is why I find it really useful and really interesting. I guess how it's different from other types of feminism. And
Before we move on to how it's different from other types of feminism, can you give us an example about what this dismantling of inequalities between the human and the non-human subject means? What does that look like? And why is this relationship between the non-human and the human subject so different from other forms of feminist theory, particularly? Like, what is it? How does that differ from the focus of other forms of feminist theory? I'm aware that, you know, the other stuff about dismantling hierarchies is well embedded within most feminist theories, but that question there on the distinction between the human and the non-human subject, I think it'd be really good to unpack further.
Mm-hmm. Yeah, no, that's really helpful. Yeah, I guess in terms of thinking about a kind of more concrete example, I mean, probably the easiest one is to take one from international law, of course. So if we think about international environmental law, for example, lots of different scholars such as Julia Dem and Usha Natarajan have really kind of challenged that body of law for focusing really on nature as being an economic resource. So the environment is only ever seen as object, and humans are the subjects that therefore exploit it for mostly economic gain. And so post-human feminism can be used to say, well, what happens if we challenge that binary? What happens if we think about the environment also as a subject? So there's no kind of subject-object split here. And that can kind of bring in debates around, should we have the rights of nature, or should we think about the law in a very different way, and thinking about indigenous ideas around also the environment as well. But yeah, that's kind of one more concrete example of how this can be applied. And I guess, yeah, that brings in that how is it different to other types of feminism? Because of course there are lots of feminisms that focus, for example, on the environment, probably most notably ecofeminism. But I think what is different about post-human feminism is that it kind of brings all of these different feminisms into conversation in a way. So I'm reminded also of Gina Heathcote's work here around plural feminisms. You know, how can we bring queer feminisms with post-colonial feminisms, with ecofeminism, etc., together to kind of provide a more holistic critique and analysis of the law? So that's kind of how I see it in relation to feminism, if that makes sense.
Yeah, that makes sense. And so, I mean, I'm going to ask you to kind of go a step behind there of like, well, why do we need that sort of feminism? Isn't feminism in and of itself about equality? So why do we need these, or why do we have all of these different sorts of feminisms then within all of our theories?
Yeah, I guess so. Again, a really huge question. But I think we need lots of types of feminism. So I guess for most international lawyers, when they think about feminist approaches to international law, they think women's equality, women's representation, maybe women, peace and security. It's pretty much what most people think
Probably also sainted Judge Charlesworth.
Yes, at this stage, which, you know, that's a great association too. So that's good. But yeah, I think what is important is to recognize that feminist approaches to international law and feminist theory has always had a lot more to say. It's not just about kind of women's representation or women also need human rights. We've always had, and you know, Judge Charlesworth's amazing work is really exemplary of this. You know, feminist analyses of the law of treaties, of the state, of international economic law. And those kind of issues tend to get sidelined. I think like most international lawyers are not even aware of that work. So I think, that's why we need to bring more feminist theories to international law, to say like, hey, actually, feminist theories have a lot to say about everything in international law. It's not just kind of the issues that you associate them with. So yeah, I think for me, that's why. And then post-human feminism allows me to bring in lots of different forms of feminism, if that makes sense.
Yeah, that does make sense. That's a really great synopsis. And so, you've done a lot of work on post-human feminism in international law. So what does post-human feminism do for international law? What does it bring to international law? What does it mean for international law for our listeners?
Yeah. Well, I guess one example that I gave was thinking about the environment a bit, but I think another good example would be thinking about technology regulation, and probably a good one to bring in because we haven't talked much about that yet. So post-human feminism, another thing that it does is really think about bringing in kind of science and technology studies and feminisms from there, etc. It challenges the distinction that we tend to make, and particularly in Western thought, between the human and the machine. So the human is always being seen as in control of machines as opposed to being in connection with them. And so I apply this in the book to think about debates around autonomous weapon systems and bringing post-human feminism to that realm. So one of the core debates about autonomous weapons is, of course, whether we should ban them or not. And kind of caught up in these debates are kind of, can these systems apply international humanitarian law? What happens in terms of accountability, etc. And what post-human feminism does is allow us to kind of take a bit of a step back from that and say, well, there's kind of a binary thing going on here because so much focus is, and actually that is the way that disarmament law is also set up. It's ban or allow. And that's actually quite unhelpful. Because if you ban something, that thing has to be defined, of course. And there's a big risk that if we do ban autonomous weapons, that they'll be defined in such a limited way that that ban actually won't mean very much. And actually, a ban may even legitimize everything that's not banned, right? So this is kind of concerning because if the main ethical concern about autonomous weapons is if we should allow machines to kill or not, well, the focus on a ban actually sidelines that question. Because machines are already making life-death decisions, because as post-human feminism tells us, machines and humans are in connection. So this kind of focus on autonomy and this kind of other machine is a bit of a kind of red herring in a way. So yeah, this is kind of something that post-human feminism can allow us to see, and we can think about also the distinction here between autonomous and automated technologies, and the line there as well between that supposed binary that's often kind of used in the literature to say we should ban something and not something else is really not clear cut. And I think a really good example of this would be drone warfare, actually, because drones are always seen as, it's a legitimate part of war at this stage, or it's supposedly, and they're seen as distinct from autonomous weapons because there's a human operator, etc. But the problem is, if you look at how drone warfare works, if you gather kind of GPS evidence and all the various intelligence available, mobile phone tracking, etc. In the end, there's a file created about someone that has been, compiled by machines that is huge, that basically says this person is probably a terrorist. And the kind of question then is, well, at what stage is the machine actually making the decision? If you're given this file that's huge that says like, all of the data says, you should target this person, then at what point is a human actually still making that decision? Or is it actually a human and a machine together? So I guess the point of this is that in the end, if we're concerned about whether machines are making life-death decisions, well, they already are. And that's what post-human feminism shows us. And it kind of allows us to take a step back a bit from that kind of ban or allow position. So that's kind of another example of how this can be used.
Fantastic. So with those compiling of data that says this is a terrorist, you're basically saying that functionally there's so much data there that a human can't reasonably sift through it in the time it takes to necessarily make that final targeting decision, and functionally the line between the human and the machine in terms of decision making doesn't exist.
Yeah, exactly. And there are lots of different examples of this where kind of technologies are making these decisions. And of course, there's human oversight. But yeah, at what point is there not enough time to make that oversight or to make that judgment? Or, at this stage, we rely a lot on technology. If like technology tells us that something is probably the case, a lot of the time we just say, yeah, sure. So yeah, exactly.
Yeah, we've seen that domestically in Australia. I think we've seen that, at least reports of that, in relation to various military's targeting mechanisms about in terms of determining targets. And I think you're right there. Can I get you to kind of go back to the environmental stuff that you talked about as another thing? Because you touched on it. And I know you've done some really interesting both queer and post-human feminist work in this space. What do these theories mean for environmental law? That removal of the subject object binary. How does like It's clear how it works in the technology side of thing. How does it work for environmental law?
I guess in terms of international environmental law, as I said at the start, it's being critiqued for defining the environment very much as an object to be economically exploited. And this has been kind of argued as being one of the reasons why the law has failed to address the urgency of the climate situation. And what post-human feminism can do is to kind of say, well, how do we challenge that? How do we think about the law differently? So we have all of these theories in the humanities that are already looking at what happens if we think of the environment as a subject itself. So how can we apply these here? I mean, in practice, I think it's really, really difficult because there's this constant tension as an international lawyer, right? Especially if you're doing interdisciplinary work, where you're trying to apply these kind of theories from outside the law to the law that has its own structure and framing. And so it's kind of how do we make incremental steps and try and kind of just recognize new entities in international environmental law? And kind of one way of doing that would be through, for example, rights of nature paradigms, which say the environment should be a legal subject. It should be able to bring its own claims in court. But at the same time, there's something that is still quite limited by that because you're just kind of making the environment another subject. And international law has always had non-human subjects. I mean, the corporation, arguably the state is obviously the obvious one, international institutions. So is it going to be that transformative, I think is the wider question. And post-human feminism also allows us to kind of ask some of those questions as well.
I think that's given a really good synopsis of what post-human feminism is and what it brings and what it means for international law. Do you have kind of anything else that you want to add on these questions of post-human feminism before we kind of move on?
I guess the other thing that I wanted to return to, you asked a little bit about queer theory before and
Yeah.
yeah, and how post-human feminism relates to that. And I think that that's also quite a good question because they're similar to me in a lot of ways. And, I think could be charged with conflating at times in my work, but I think they come from different perspectives in a way.
I would absolutely agree. They come from different perspectives because I'm very much a queer theorist, but I have not worked in post-human feminism, but I'm very much a queer theorist. So I would agree that while they might get conflated in some of your work, they're just, I think, distinct frameworks.
Yeah, I think they are. And I think that that's important to note because I guess post-human feminism it's got this focus on inequalities, but it's really this kind of non-human human binary that it's challenging. Whereas queer studies, of course, comes from, anti-normativity and from a kind of queer lived experience. And that's
Yeah.
also different lineage.
Yeah.
And they
Yeah.
can conflate. The chapter that I wrote for you is queer theories of the non-human, of course. But yeah, sorry.
Yeah, I mean, I describe queer theory when to people who have never worked with it as a starting point of queer theory at its core is fuck your normativity.
Exactly. Yeah.
That's the
Yeah. And
starting point I bring to queer theory when trying to explain it to people and why we use it is it's about that whole fuck your normativity. Let's interrogate those assumptions around normativity and what they do. So
totally.
yeah,
Yeah.
yeah,
Yeah. And I think that that's quite And like I said, they can come together. So like the queer theories of the non-human that I'm using in the chapter that I wrote for your edited collection, look at how, well, queer subjects have always been other, and so has the environment. So what happens if we kind of bring that together and think about all of those kind of outside anti-normative subjects and try and think about international law from that perspective? But yeah, I think there is a kind of different lineage there that's actually really important to recognize.
Yeah,
Sure.
I think you can see that in the genesis of queer theory, which still has very much a core focus on queer lives as a core focus, not a sole focus. And I think that that's the mistake that people make with a lot of feminisms as well, is that they see feminism's core focus on women's lives as a sole focus, whereas I'd say that the uniting point of all of these different things is it's about fighting for equality with a different lens applied to it, but it's understanding that difference between core focus and soul focus, whereas the core focus, from what I understand on posthuman feminism, from what you said, is it's unpacking and problematizing the subject-object binary in thinking, whereas the core focus and lineage of queer theory is fuck your normativity and the assumptions it causes, which often means that they can work really well together. And I think your work is a fantastic example of how they come together, but it does mean that they bring slightly different lenses to the same problem.
Mm-hmm. Yeah, definitely. I think so. But I was also thinking as you were speaking though, Tamsin, about like that's one of the core tensions in queer theory as well, isn't it? And I think especially in kind of queer approaches to international law that we're seeing emerge, there's kind of this split between people that are doing this more anti-normative work and then people that are doing kind of what could be called more LGBT rights work. But then at the same time, I'm sort of reticent to say that's, you know, one is queer and one is not, because I think that there are ways of queering both. But I think queer theory is not necessarily, it's hard to pin down and to kind of apply in some ways as well, right?
Yeah, and we had to, like, Claire and I had to wrestle with that in how we framed, particularly the queer encounters with international law book more than the queer engagements with international law book, by kind of, we ended up settling on a definition of queerness that actually Emma Genovese and I came up with in a law and literature piece we did, which, as far as we were concerned, queerness was any way of being that questions structural heteropatriarchal systems. And that was our framework to be radically inclusive. But that's really controversial, even within that distinction, as you said, between LGBT rights work versus queer theory on queer lives, and that tension there. So it's a really tough one, because there's a lot of work that, as you said, would be considered fairly mainstream, just rainbow community rights work, that wouldn't fit within the anti-normative framework of queer theory, because it's pretty much advocating for respectability rights frameworks.
Mm-hmm.
And for anyone who wants to kind of see what that critique looks like, I would thoroughly recommend picking up Emma Genovese's UNSW Law Review article called The Spectacle of Respectable Equality, because it's a banger. She's done an amazing job of unpacking that issue. But at the same time, those of us in queer theory, I don't think we want to exclude them from the broad and inclusive tent and community we've set up, because there's still value in that work.
Mm-hmm. Yeah, and there's still a need to queer rights, if that's possible. And I guess to add to the reading list, I would really recommend Ratna Kapoor's chapter in the first Queering International Law volume that Diane Otto edited, because I think that that's such a good critique of rights. And it's quite controversial. Like, I've set that for students, and some of them hate it, some of them love it. But I think to get you thinking about these issues, it's a really good one. But I guess this kind of leads on quite nicely to my question for you, Tamsin, actually, which is much more about, lived experience, I guess. So yeah, in the tradition of this podcast, I have a question for you. And it's based on kind of some of the ways we've connected over the past few years and how we've had some similar and different experiences, because both of us are queer disabled academics. And as some of your listeners will know, I've been battling cancer for the past couple of years, just finished 21 rounds of chemo. And what was really interesting about that journey is how some people really reached out and were totally there from afar. Others didn't, and that's a different story. But you were very much one of the people that made sure that you were like really present, and I really appreciated that. And as I said before, we already had a bit of a queer connection, but what meant a lot to me about kind of your reaching out and about our chats that we've had these past few years is that we've been able to talk quite a bit about just how shit it is to be disabled and how the world is not set up for disabled people. And yeah, you've really helped me come to terms with, I guess, becoming disabled, which has been really great. So thank you for that. And so that leads me on to my question, which is about that kind of shared experience. And as someone who's queer and fairly new to being disabled, and on behalf of the other queer and or disabled mind-bodied international lawyers out there, I was wondering if you could share your experiences of what it's like to be a queer disabled academic and a queer disabled international lawyer, and namely what challenges you faced and kind of in what ways do you think this informs the work that you do? So yeah.
Yeah, okay, so this is a big and complex one, so I'm going to try and keep it concise, and that is, as much as everyone wants to say we are in a, inclusive society, that's all for being queer is fine. For the most part, that's kind of bullshit. It's only fine to be queer if you are one of the respectable queers. Otherwise, it's kind of uncomfortable for everyone, and there's this structural exclusion of I like to put the distinction between the queers and the respectable gays, but it's anyone who's in the community will understand that distinction. It's not a down putting on people who I actually worked with a colleague at UNSW Canberra who referred to herself and her wife as vanilla dykes. And that sums it up as best as I could. And that was her term. I would never say that about someone else and their lived experience as part of the queer community, but that was her term. And I think that also sums up that distinction between the respectable gay and the queer. And that's hard because the respectable gay, as Emma's paper really puts in, is actually well integrated into law and society now. And so it's often got people thinking that that's the end of the discrimination, but it's really not. Anyone who read the interview, the person behind the academic interview I gave to Volkerech blog last year will know that I had a moment at a previous law school I was at where I was pulled aside by someone pretty senior after they met me and they'd only seen my work on paper, who said, if I knew what you looked like, I would make sure you'd never have gotten a position here. And they did it in a way that made sure there was no record of it. It was my word against theirs. And I couldn't do anything about it, but I knew from word go I was unwelcome. And that's the hard part. And that's the part that's kind of, it set the tone for places I'm willing to work and places I'm not. I won't work at that law school ever again. I won't. I'm not welcome there. It doesn't matter what changes there. I will never believe that I am welcome there. I love it at Deakin. I'm very welcome. I'm very well supported. I have a great faculty support network. Yes, there have been individuals who have been less than supportive, but I've always had the support of my university, of my dean, and all of those structural supports to say that I am welcome here as I am. And that makes the world of difference. And so in terms of navigating professional stuff, I make it really clear on my cover letters when I'm applying for jobs that I'm queer. I don't hide it because if that causes me to not get shortlisted, I have learnt that I don't want that job. I don't want that job. I make sure that while I'm dressed very professionally for interviews when I've gone for jobs, that my tattoos are still visible. Because if me having visible tattoos is going to stop me from getting a job, that's an environment I don't want to be working in and subjecting myself to. And I get that that's really, really hard when you're still in the precarious career positions. I I get it because I've been there. I've had to go through that. But also the damage it will do to your long-term health and well-being to have to hide that side of yourself constantly to have a permanent job. There are other places that you won't have to, and it's worth pursuing those rather than accepting a bad job that's going to break you. In my mind, that's not going to be right for everyone. I'm not making that prescriptive, but that's about my navigation. I take a very similar approach to disability, and I'm my disability is somewhat invisible in that if I'm having a good day and don't need my cane and that no one can see that I'm disabled. I have a major spinal disability, but it's not visible because it's entirely internal and you wouldn't know. But it has a lot of material impacts, and some of those impacts are more kind of obvious than others. I can't fly economy. I literally can't fit in the seats with my spinal disability. And that's a huge hurdle. I can't do work travel unless work is sending me business class. And so I need to have those disability adjustments in place. I need to know when I go into a job that I'm going to be supported as someone who's disabled. And so for the same reasons of I need to know that I'm going to be supported as a very openly queer woman in my jobs, I make it really clear when I'm applying that I'm disabled, not just in the checkbox diversity one. I put it in my cover letter. I am disabled. I'm I turn these things into a positive. I literally say this will add to cultures of diversity in the law school, blah, blah, blah. But I make it really clear and I'm really upfront about that because actually I know long term that if I get in there and they weren't aware and I can't point to where they should have been aware and I don't have that support, that's not a job I'm going to be able to stay in. And again, I'm really well supported at Deakin. I've never had any questions from anyone about making sure I have all the disability adjustments I need. But HR will make you have clear medical documentation to show the adjustments that you need and why you need them. And you'll have to check that off every time you want an adjustment. My travel needs to be signed off on by the VC because as a disability adjustment, it's business class, and university policy is that business class travel has to be signed off by the VC. It makes it really uncomfortable for me to have to travel, knowing that I have to get the VC's approval, but I also know that I've got the support of my dean to do that. If I was at an institution where I didn't have that support, I wouldn't be able to do my job. I can't type. I have to do everything with voice recognition software. This means that if I don't have a system for marking papers that allows me to give highlight and click comments and voice recorded general feedback at the end, I can't do any marking. Um, as previously noted at the start of the thing, I'm dyslexic, which means if I can't require font and font face and text alignment in submissions, I can't read what's being submitted by students to market without it taking me forever and giving me a headache trying to mark one paper. So how do I navigate that? And I feel like I'm rambling here a little. I navigate that by the fact that when I apply for jobs, I'm really upfront. I'm really clear on what I need and why I need it. And while I have support for that, I also know that at every step in the road, I need to be the most calm and most reasonable person whenever there's a question about those needs or about my inclusion of my queerness, because I also know that if anyone isn't on board and fully supportive and doesn't know me, if I'm not the calmest and most reasonable person in the room, I'm going to be dismissed. And it's hard and it's awful. And it really is about making sure that you're somewhere that's supportive of you and wants you there, knowing all of those things before you even get there. And that's about all I can kind of say on that. How does that kind of brush with your more recent experience, Emily? I'm really glad that I was able to kind of help you navigate.
Yeah. Yeah, I guess what kind of really resonated for me with listening to like your reflections is that the fact that we always have to take the burden on ourselves. It's like the world is just kind of, yeah, you don't know when you're going to be discriminated against. You don't know when people are going to like secretly not support you, even if it's not clear. You know, we have laws in place, but it doesn't mean that you're not discriminated against. And just having to take that burden on yourself is just an extra thing that able-bodied and, heterosexual straight academics don't have to do. So I think that that's, yeah, really hard. And I mean, I guess I always had to navigate that a little bit with my queerness, and I kind of found ways of doing that. I think at one point I kind of like purposely used to dress kind of really queerly and kind of, wearing black lipstick to work and things. And it was my way of being like, this is who I am and you have to accept that. But there's also kind of the side that you were talking about in terms of like travel and how you need extra things. You have to travel business class to be able to even travel. And that really resonated with me too, because I think one of the things when I got my diagnosis was I was kind of like, everyone's going to forget about me. No one's going to care about my work. I can't go to any of the big events. My book was coming out. I'm not going to be able to advertise it. And yeah, I read this amazing book by Logan J. Smilges recently called Crypt Negativity. And I have no idea if I said their second name right, but and they have this quote where they say, it's not the fear of missing out, it's just missing out. And I remember reading that and that just like hit me so hard, because you're just missing out and it's really hard. And I don't think that most academics ever think about that. And most international lawyers even. Look at the number of events that are not hybrid, for example. So, yeah.
And yeah, like that's been, as I said, it's been made exponentially worse since COVID because we've hit a point in the ongoing pandemic where COVID precautions are seen as unnecessary. And those of us with major disabilities, so that's both you and I, we can't take that risk. We don't have the luxury of being able to be lax with risking getting COVID because, I mean, for me, getting COVID is a 50-50 on whether or not I have to learn how to walk again. I don't know what the implications are for you with your immunocompromised status from the cancer, but I know what it is for me. And I can't take that risk. I also know that even a big conference, I can't get through a full day because, like, even with my cane, by the end of the day, I'm in agony. I can't do a big conference. It hurts. It just hurts. And so, yeah, it's not the fear of being left out. It's just being left out so often. And it's why I advocate so hard for everything being done hybrid and all of that, because it's an inclusion, it's an accessibility question. And yeah, it's hard time zone wise for me in Canberra when, it's a conference in, let's say, Newcastle where you are, and time zones mean that even if it's hybrid, I'm up all night, but I can make that work for a couple of days better than I can make the agony of flying, the structural difficulties of getting approval to fly, and all of the not knowing if I'm going to have a bed that's going to make a mess of my back and make it so I can't actually function while I'm there, and all of those other hurdles. It's still easier to engage hybrid than from a remote one than it is physically getting there. Yeah, anyone who says that hybrid stuff is a luxury or unnecessary has never had the access issues that you and I face.
Exactly. Yeah. And I think the other thing that is really important to note there is like just how exhausting and how painful going to a conference can be. That's something that's really like shocked me, having been pretty able-bodied before. Like I just can't get through a day without sleeping. And yeah, if I'm sat in a chair all day, it just really hurts. And people don't ever think about that. They just take that for granted. So the importance of breaks, the importance of like having a room that you can go to and actually have a sleep in, for example,
Well,
you
and
know, all of those.
even
Yeah.
just little things of like at a conference, I need my cane. I can't line up and get a coffee and get food and carry it while using a cane to then get somewhere outside so I can take my mask off and have a snack.
Mm.
And if there's nowhere I can kind of even sit outside because I can't stand with my cane and juggle all these things, I don't get a break at all. So
Yeah.
yeah,
Yeah.
it's rough. And the only thing I can say is, yeah, the hardest part is that exclusion and the fact that you always have to be the calmest, most reasonable person in the room, because otherwise you'll be dismissed as hysterical and overreacting. That's the bit that sucks. Finding a space where you have support, though, is just so crucial to being able to stay in academia and doing good work. And having the people who will amplify your work, even if you can't get to those conferences, is so key. And I'm really fortunate to have that. I like to think that you have that as well, Em. But yeah, that's kind of my response to
Yeah.
your question. I hope that that's helped, like that resonates with your experience, but I hope it also helps for our listeners.
Yeah. No, I think that that's a really important response. And it's just really, yeah, really important to actually talk about those everyday experiences because we just don't as international lawyers and as academics. And we need to more. So yeah, thank you for sharing that.
No, really happy to. And my other advice is on bad days, just take the good drugs and go have a sleep. Like
Yeah.
when you're on a research period, your work is output based. So if you don't have any meetings that day, just take the good drugs and go have a sleep and you'll do the work later in the day. You'll do it the next day. It'll get done, but don't try and force yourself through it because it'll cascade and be worse the next day. Take the good drugs and go have a lie down and accept the fact that it's not happening today.
Yeah, absolutely. Yeah.
Yeah. All right. So we have come to the end of our time. So I'm gonna ask you some wrap-up questions. And in addition to the recommendations that we've both already made, what would you recommend for anyone who'd like to know more about what we've discussed today, be it feminist theory, queer theory, post-human feminism, disability rights and access, queer rights and access? There's a whole list of things that it could be. What are you working on at the moment? And what's your current escape route to get when you need to take your mind off international law? What are you viewing, reading, or doing to take your mind off things?
Yeah, well, I'll start obviously with the first one in terms of if you want to know a bit more about what we've discussed today, I should probably take the opportunity to plug my book, which is, of course, Feminist Theory and International Law Post-Human Perspectives, which, yeah, I hope people will enjoy reading. And I tried to get it paperback first. It came out paperback first so that it's more affordable as well for people. So hopefully that helps. But what I actually would recommend to people in international law who are interested in all of the issues that we've talked about today is to read less law and read, so for post-human feminism, people like Rosi Braidotti, like Donna Haraway, Zakiyyah Iman Jackson is amazing on the kind of issues of race and post-human feminism. So I'd really recommend those. And I also think all international lawyers should read more queer studies because it will probably blow your mind. And here I've been going back a lot to people like Lauren Berlant, Lee Edelman, Jasper Poor, Jose Esteban Munoz. Yeah, I'd recommend reading them. And I guess the other thing I should really plug, and it's the quote that I gave before when we were talking about disability, is the recent book by Smelders called Crypt Negativity, which is one of those really like short front runner books. It's just like so good. So those are kind of my recommendations. What I'm working on at the moment, I've got kind of a few things ongoing. The one thing that I've been working really slowly on, and I've adopted a very slow method of working, is on the concept of future generations in international law. And that's been really fun. There I'm kind of saying, like, there's this assumption that international lawyers make that it's an inherent good. And actually, it doesn't have a strict legal definition, which means that international lawyers just fill it up with their own moral will. But in actuality, there's quite a dark side to the concept. It's inherently based on whiteness, and there's actually quite a lot of links to sort of neo-Malthusian population control ideologies if you look into the history. But it's also, you know, gendered, classed, ableist, anthropocentric. It's only about humans. So I've kind of been enjoying working on that one. It's a bit different. Longer term, I think I kind of would like to work a bit more on critical disability studies and international law. I think that there just isn't enough work on that. I mean, we have obviously Liz Calamandiel's article in the Leiden Journal, which is really important, but I think there needs to be more. And there's a big link there with queer studies as well, of course. So I think that's kind of where I'm going. Escape route and what I'm reading and doing. Well, I guess these days it's been more about getting my mind back on international law after having my brain basically be mush for 2 years. But I like this question. I like that you always ask it, and I always like listening to people's answers, because I think it's really important to have that work-life balance and to also think outside of our work. So the main thing I have been doing lately actually is weightlifting. I started like a program for people in their 20s and 30s with cancer while I was still in chemo. And now that I'm not in chemo, my trainer, who was ex-military, has gone really hard. It's getting me to lift really heavy weights. And you cannot think about international law or anything when you're lifting really heavy weights. So it is the best thing to get your mind off stuff. So
You and Juliet could definitely bond over that.
yeah, for sure. Sounds
Yeah.
fun. We should do it.
Awesome. Well, that's all we have time for. Emily, thank you so much for coming and talking with the podcast. And to all our listeners, I hope you've enjoyed this episode, and we'll see you next time. Bye-bye.